This Honorable Court of Criminal Appeals of the State of Tennessee is now in session. God save the United States, the State of Tennessee, and this Honorable Court. You may be seated.
All right, good morning and welcome to the February setting of the Tennessee Court of Criminal Appeals here in Jackson. Let me introduce the panel to you. My name is Kyle Hickson. I'm from Knoxville. To my left is Judge Steve Sword, also from Knoxville. And to my right is Judge Matthew Wilson. He's from right here in Jackson. I want to thank you all for being here. I know this has been a difficult couple of weeks for a lot of people across the state. And I just want you to know, out in this end, we know you guys were hit especially hard, along with the people in Middle Tennessee. You guys have been in our prayers. And we thank you for being here today. I know it's probably been a little more difficult than what we're used to. So thank you for that. As far as the ground rules go, I believe you guys are familiar with that. Each side will have 20 minutes to argue. The appellant may reserve time for rebuttal if they wish to do so. If you're going to do that, please let us know on the front end. I will let you know we do not have the fancy little egg timer sitting up on the lectern that we usually have. But we will be keeping time between Madam Clerk and the bench here. So I think what we'll do, when you get down to a minute left, we'll signal that to you in some way and then ask you to kindly wrap it up when you get to the end of your time. So with that, Madam Clerk, do we have any preliminary matters?
No, Your Honor.
Ma'am, if you'd please call the first case.
State of Tennessee versus Tony Banks and Tyrone Banks.
Good morning.
Morning.
May it please the court. Lance Chisholm from Shelby County. I represent Tyrone Banks, the appellant. Co-counsel Mr. Barry Kuhn represents Tony Banks. We're asking permission for me to do the first 15 minutes and then for Mr. Kuhn on rebuttal to come and do the 5 minutes for rebuttal.
That sounds great. Thank you.
Thank you, Your Honor. The issue in this case that I'm going to focus on is the confrontation issue. This was a bench trial held in Shelby County. Like I said, both defendants were jointly tried and were both convicted of misdemeanor assault. There was an important witness who testified from Nebraska named Brian Broyles, and he testified via Zoom. And there's not much discussion about why he testified via Zoom. It just said, hey, I'm in Nebraska, and then they put him on, to testify. He was working out over there. There was no objection to that at this trial. The defense lawyers did not object. Also, the defense lawyers never filed a motion for new trial. So the issue clearly has been waived. We do acknowledge that. But what we're asking the court to do is to find that this error was just so egregious that it rises to the level of being plain error under our plain error analysis in Tennessee. So the plain error analysis looks at 5 factors, and I'm just going to try to hit each one of these here in this time I have. The first one's pretty easy. It's whether the record clearly shows what occurred. Well, the record here clearly shows Brian Broyles testified via Zoom. So it's, that part's clear. We've established that.
There's nothing else in the record about any discussions about why. You had mentioned it was just sort of accepted he would be.
That's correct.
Okay.
It was just kind of accepted. Nobody really lodged any complaint about it at all. Our judge never questioned it. So the next issue is really the important one is, does this really breach a clear and unequivocal rule of law? So we have, the Sixth Amendment in the Article 1, Section 9, says you have a right to physically face your witnesses against you. In fact, our Tennessee Constitution has the face-to-face language, and back in 1992, the Duder case was saying, well, we interpret confrontation as giving the defendant more rights, and for a while, a lot of cases were kind of going down that road, but then recently, in the Daniels case, this court in 2022 said that, we in Tennessee, we interpret this Article 1, Section 9 just as the Sixth Amendment, essentially. We rely on those cases. So I'm acknowledging that we have analyzed those the same, and we are under plain error. So while I would love to make an argument that we should give the face-to-face more, power here in Tennessee, I think I'm bound by what Daniel said, that we interpret them the same. So I'm going to start out for that reason talking about a federal case. This is a Sixth Amendment case. It's Maryland versus Craig, 1990 case. That case, you had a child victim who was really, scared to testify in front of the defendant. So they put her in a room next to the courthouse and had the attorneys cross-examine her. And the judge, the defendant, and the jury were in the courtroom, and the victim was over in a separate room. And, the United States Supreme Court said, we don't like that, essentially. We need to remand this for some findings to see, was that really necessary? Because, it's important to face your accuser. That's a real important part of the Constitution. So they sent it back for that reason. So that's kind of the starting point there, is that federal case. Under plain error, we need to look at that case. And I would submit that case would not be would not find this appropriate, what happened here, So then let's turn after the...
Well, let me stop you there.
Yes.
It could be appropriate. Maryland v. Craig, I believe, didn't say that it was per se unconstitutional to proceed in this fashion. So under some circumstances, it could be proper. Under some, it could not be. So how can you show a breach of a clear rule of law here if there was a possibility that this could, in fact, have been a constitutional reason to allow him to testify via Zoom?
Well, Your Honor, the way I read the Craig case, it says, let me quote the exact language here, that a defendant's right to confront may be satisfied absent physical confrontation only where it's necessary to further an important public policy or where their liability is otherwise assured. So in that case, you had they remanded it, but at least you did have some good reasons. This child being scared, they said, we got to see if she's just scared of being in the courtroom generally or if she's really specifically scared of this defendant. So they remanded it for that reason. So it has to be important public policy. And, in this case, there was nothing stated at all. I mean, we don't even know if this Brian Broyles lived in Nebraska or if he was just working there for a short time. There are other cases I cite in my brief in Tennessee I'm going to get to in a minute where, a witness had COVID and the court seemed to say that, suggested that could be a reason. But here, there was just nothing at all. And that's why I think it rises to plain error because had there been any indication, such as that Adam Holmes case that found there was no plain error, I think, because the witness had COVID, then I could understand, we can't really show plain error because there is some reason here that could be, relied upon, but absolutely no reason is provided in this record. So then I want to turn to the Daniels case again. It says, it's a reported decision that says, confrontation may occasionally give way to public policy and necessities of the case. So that's 2022. But really the most important case dealing with this topic is in 2020, Dennis Lee Seal. In that case you had witnesses who were in Virginia, and one of them had dementia, his wife had dementia, one's kid was starting college, one was undergoing cancer treatment, and one said it was just emotionally too burdensome to come to court. And that court said, the trial court said, those are good reasons, but on appeal, this court said that, no, basically what it said is that, face-to-face is so important because we want the witness to feel, the power of, actually coming to the courtroom, that makes an impression on someone, that by being there, someone's life's about to be affected by what you're about to do. And it stressed that that's really an important component of this face-to-face clause. So it said we're not inclined to remove the requirement of physical presence except for instances which most necessary for public policy considerations. Now I read that to mean it's got to be something very serious. They didn't even, this guy's wife had dementia and cancer. One of the witnesses himself was undergoing cancer, and they said that wasn't even, we have to have a hearing to see, if that's even going to qualify. But in our case, we don't have anything other than the guy saying he's in Nebraska. I mean, we got to make witnesses travel to court is my position on these for the face-to-face clause. Just the fact you live out of state is not a good reason in and of itself.
It seems to me to be complicated by the fact that there was no objection below. And I know you guys are getting the record as you receive it here on appeal. But how do we know that there weren't conversations taking place between counsel at the trial court level? You know, I could imagine a situation where the state would say, hey, Mr. Broyles is in Nebraska. We can't get him here for the trial. We'll have to ask for a continuance if you insist upon face-to-face confrontation. Maybe the defense says, no, I don't want a continuance. We want to try the case. We want to have a speedy trial here. We're okay with Zoom testimony in this instance. Given the fact that there was no objection, how do we know that that wasn't the case?
I mean, that's certainly a good point that, you know, that could have very well happened. You know, they want to get the trial going, but I think what says it best, you know, if you look at under plain error tactical reasons, and I didn't put this in the brief, but it's a case that, as I was preparing for oral argument, I remembered State v. Michael Smith. If I can get this, is our Tennessee Supreme Court, 492 Southwest 3rd, 224, says, this court has held that absence and indicia in the trial record, the defendant has waived the issue for tactical reason. I'm sorry, let me start over. That an absence of indicia in the trial record that a defendant waived an issue for tactical reasons is sufficient to satisfy this criterion of plain error. So in this case, there is an absence. You really can't tell in any way, shape, or form if this was strategy. It really would be assuming, because you could just as easily assume these lawyers did not know this violated the confrontation, you know, that they may have thought it was okay to have a Zoom witness. So I don't think we can, unless there's something in the record suggesting it was tactical. The way I read the Smith case, we have to assume that it was not tactical, would be my answer to the court's question on that.
And I've really, to be candid, I have struggled in applying that tactical prong of plain error. Because on one hand, we're told it's the appellant's burden to prove that plain error exists. But it seems like in some cases we see, as you mentioned in the Smith case, the appellate courts will presume that there is no other tactical reason for there not to have been an objection. So that prong will be met. I've had difficulty in application squaring that. Do you have any insight on that?
I mean, I certainly understand your struggle with that, because I've been arguing plain error for a lot of years, you know, and I've thought that through a lot, and I think that the best answer I can give you is that following the Smith case, you know, unless there's truly some indicia in the record that this was probably for a tactical reason, I think we have to assume it was not tactical, because it could have just as easily been they missed the issue, you know, and you have to, I mean, I was obviously, as advocating for the defendant here, that's the position I would ask the court to take, you know, that we have to, we can't just assume it was tactical.
Let me run this by you, because this is kind of how I've attempted to square it up through the years. You get some cases where you can look at the record and you can look at the issue and you can say, you know, even though the record's silent on this, there is no good reason not to have objected in that instance. Have that category of cases. On the other hand, you have cases where the record's silent, but you could envision reasons why counsel may not have objected. And when I look at this case, I'm thinking, okay, why would counsel not have objected here? Maybe they didn't want to continue the trial, as we mentioned earlier. Maybe they didn't want to emphasize the witness's testimony by having him appear in person. They might have thought that his testimony would have been less impactful in front of the jury via Zoom. Aren't those very reasonable things that could have happened here in this case?
I certainly think those are reasonable explanations that could have happened. I do concede that, but at the same time, we're just speculating there, you know. I mean, those are great reasons, but is there anything in the record to support that? I think that's what we have to look at. If the court could point me to something in the record that strongly suggested this was, they didn't want to reset the trial or whatever, I could see that being a good reason. But I think it becomes dangerous if we start assuming what's in these attorneys' minds when nothing in the record supports that. And that would be my answer, that we follow the language in that Smith case and construe it that way, Your Honor.
I think you also have to look at what's in the judge's mind when you're alleging that the judge made a plain error. Adam Holmes, which you mentioned, was a case near and dear to me. I tried it. It was a case where the parties just come in and says, hey, this person is going to be testifying by video. No objection. We both agree this is the way to do it. And as the trial judge, sitting here thinking about 50 other things that I need to be worrying on, great, they've solved this issue for me. So I didn't say anything. And so for plain error in that case, it would have to show that I breached a clear, unequivocal rule of law. And since you can have video testimony in cases like this, even though you don't have the Maryland versus Craig findings, how can you show that it was a clear and unequivocal breach of law?
Well, I think in the Adam Holmes case, I agree with the Court of Criminal Appeals that you did not breach a clear and unequivocal rule of law, because there was mention that that witness had COVID. I think that witness was in the jail, and she testified via Zoom. So there was something actually in the record that supported, that's just common sense. Y'all probably all thought, that's a no-brainer. Somebody has COVID, we don't want them in the courtroom. That seems to be an important public policy, as Seal and Craig talk about. I just keep going back to this case.
1 minute, Mr. Chisholm.
1 minute,
Yes, sir.
So, again, in this case, there was nothing mentioned about any COVID or child witness, that the guy was sick, anything like that. On my last minute, I just want to say this was an important witness. The judge and the prosecutors, they kind of relied on his testimony where he said that the defendants kept going after the victim when they were trying to break it up. And that's kind of what put the judge voting on the side of guilty over not guilty. When if you read his ruling, he's like, this witness had no dog in this fight, and he said these things. So it's an important witness. So I'd ask the court to reverse the case, the conviction.
Thank you, Mr. Chisholm.
Thank you, Your Honor.
Appreciate that. We're not getting text messages up here, by the way. We've
That's the multiple timers.
Good morning, Your Honors. May it please the court. Benjamin Barker on behalf of the state. Your Honors, this court should affirm the defendant's convictions because the evidence was sufficient and because the trial court just did not commit plain error in allowing this witness to testify via Zoom. The state will rest on our briefs as to sufficiency, so I'll just talk about the confrontation issue. As the defendants recognize, we're here on plain error. There was no motion for new trial. There was no contemporaneous objection. And the defendants just can't meet plain error here because, first, the trial court didn't breach a clear and unequivocal rule of law. I hate to kind of rehash what y'all have already talked about up here. This court applied Maryland versus Craig and Seal and said that two-way video testimony can be appropriate as long as the trial court makes certain findings that important public policy interest outweighs the confrontation right in that case. But I read State v. Holmes to completely foreclose the defendant's plain error arguments here. The way Holmes treated it, the court could not have committed plain error because two-way video testimony is appropriate sometimes, and that just didn't breach a clear and unequivocal rule of law. I think that's the right reading of Holmes. And beyond that, this consideration of this error just is not necessary to do substantial justice. I know Mr. Chisholm says this was an important witness, and I don't want to say he wasn't important, but the evidence would still have been sufficient even without.
Mr. Barker, are you aware of any authority that even with acquiescence or failure to object, the trial court is required sua sponte to conduct an independent analysis?
I'm not aware of any besides Seal says that the trial court must make these findings. But any gaps in the record here are really on the defendants for not objecting. So it's the defendant's burden to establish plain error, and I just don't think they can here.
What about Mr. Chisholm's differentiation between Holmes and this case? In Holmes, there was something on the record, at least explaining why, and it appears like from this record, there's nothing.
There's nothing besides, just the witness mentioning that he was from Nebraska, and that was really it. And if the defendants wanted to build up a record on that issue, they could have done that below, and they didn't. And that really just thwarts plain error here. Again, it's just not necessary to do substantial justice for this court to consider this error. Mr. Broyles was really a tangential witness who just gave a more complete picture of the story. The evidence would have been sufficient with the victim's testimony alone. Mr. Broyles maybe was helpful, but the state's case doesn't completely unravel in his absence.
What do you make of Tony Banks' argument as to the silence of a waiver? You just mentioned the Seal case where this court said you have to make these findings. And then appellant Tony Banks argues, well, in any other constitutional setting, we would require a waiver on the record. And that didn't happen here. Even if there wasn't an objection, it seems their argument would be, well, the trial court should have stepped in and said, wait a second, are you affirmatively waiving your right to confront this witness? What do you make of that argument?
Even if that's the correct way to interpret the waiver, the defendants still have to establish, above all, that it's necessary to do substantial justice. And for the reasons I've stated earlier, I just don't think that they can meet that here. And I kind of have similar struggles, to Your Honor, about how to apply this waiver in the context of plain error when it's the defendant's burden, or at least I guess the appellant's burden, to establish plain error. And the kind of the two buckets of cases where maybe there's not a good reason to make an objection, but in the other cases maybe so. I think that's a common sense way to handle those. But here, as Your Honor's picked up on, I think that there were valid reasons not to object here. This was a bench trial. We had a tangential witness. It very well could have been a matter of just professional courtesy that the defendant's counsel allowed this to happen, and that they just didn't put it on the record. But at the end of the day, just all five plain error factors aren't here. That's a steep hill to climb, and they're just not here. If this court has no further questions, we ask that you affirm. Thank you, Your Honors.
Thank you, General. Mr. Coe? Morning, sir.
Please, I'm Barry Coon. I'm from the Shelby County Public Defender's Office. I represent Tony Banks in the case. And I think in response to Your Honor's question, and I'm going to argue the Moman case, in that case, the defense lawyer just told the client while they were walking into the courtroom, you don't have to testify. And they got into the court and they told the judge, my client's not going to testify. And the Tennessee Supreme Court said, no, you can't do it like that. You've got to voir dire that man to make sure he understands what his constitutional right is and that he wants to waive that right. And in fact, in this case, the judge did that with regard to the defendant's right to a jury trial. My client signed a waiver after being questioned by the judge. Do you understand you have a right to a trial by jury, and do you want to waive that right? They didn't just take it based upon defense lawyer's statement that my client wants to waive it. So I argue in any constitutional right that a defendant has, the court has to make sure that he understands what that right is.
Any constitutional right?
I think so, yes, sir. I think that's what I would argue.
I would imagine you've seen a few jury trials in your day.
A few.
And you've probably seen defense counsel, after a state's witness has testified, say to the court, Your Honor, I have no questions on cross-examination. of this witness? Are you suggesting the court should pause the proceedings to voir dire the defendant at that point and say, are you sure you don't want to ask this witness questions? You have a right to confront him, cross-examine him.
Well, cross-examination is one factor of confrontation. Confrontation has the two factors. One, the witness has to be in the courtroom and personally face the defendant and to testify.
Well, if they don't have, you're saying they wouldn't have to voir dire the defendant in that instance?
They wouldn't have to, no, sir.
Why would they in this one?
Well, I'm not sure that the right to testify is not written into the Constitution. Confrontation is, but then cross-examination is certainly. I mean, the court couldn't say, no, you can't cross-examine this witness.
Sure.
And that would be a violation. And that would be, I think, certainly subject to plain error. If the court said that, you can't cross-examine this witness. But if the defendant wants to waive his right to counsel, the courts always examine them about, they always voir dire the defendant about that. The right to testify, the right to the jury trial, they ask the defendants about that. Do you understand you've got a right to a trial by jury and you want to give it up? I think confrontation fits in the same boat. It's an important constitutional right. And we can't speculate about whether or not, for some tactical reason, he may have given it up. It has to be shown. And even if it's shown, even if I think, and my argument is, even if the state came in and say, we've got this witness in Nebraska and he can't get to Memphis, we can't afford the plane fare and there's no way to bring him here. The only way we can get him is by Zoom. The state still has, the court still has to voir dire the defendant and says, do you agree with that? Do you want to give up your right to confrontation?
Mr. Kuhn, would it be our job as an intermediate appellate court to announce this new procedure?
Well, I don't think it's a new procedure, Your Honor. I think it's just something that logically follows from the Momin case. That in that case, it said because a constitutional right was involved, the defendant needs to be voir dired. So it's a matter of interpretation. I don't think Your Honor is making a new rule.
1 minute, Mr. Kuhn. You have 1 minute left.
Let me just, in 1 minute, let me say something about sufficiency, if I may.
Yes, sir.
I know Your Honors are going to say it's often written in the opinions that the credibility of witnesses is something solely determined by the trial judge or the jury. This was a court trial, by the way, and we can't speculate about. We can't really go much into credibility because it's the trial judge that gets to see the witness testify and decide whether he's telling the truth or not. But I think an important part of credibility is not just how a witness looks on the stand, but whether or not his story is credible. And I would submit that this Mr. Rivers, the victim's story about what happened is not as credible, is not very credible at all, that the defense story that they had an argument about the lift and he drove off with the lift and the defendant had to grab his bag out of the lift, but the defendant didn't try to fight him at that point, and there was no argument at that point. It was when he got to Mr. Broyles' office and the victim thought that he was going to complain to Mr. Broyles about what had happened earlier, that Mr. Rivers stopped him and grabbed him by the shirt and threw a punch at him. And I think that's a much more credible story about what happened than Mr. Rivers.
Okay.
Thank you for letting
Mr.
me
Kuhn.
go over time.
Yes, sir. Thank you. Thank you, counsel. Call the next case, please.
State of Tennessee versus Justin Johnson.